Hear ye, hear ye. I am the Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court, I admonish to draw nigh and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Good morning. Welcome to the second and final day of the court's March oral arguments. It appears, just for those of you who are advocates who have not been with us recently or at all, the first 2 minutes of an argument on application are given to you question-free by the court, and you're to use those moments, and 5 minutes in the calendar case. You're to use those minutes to get to the outcome determinative issues in the case that should compel us to decide the case in your client's favor. We have read the briefs. We don't need recitations of unnecessary facts. Get right in and focus on the important issues. We're going out of order today. We're going to begin with Hecht versus National Heritage Academies. You're making a habit of this. Making a habit of this.
I know. A habit I enjoy. Good morning, Your Honors.
I thought you were sitting on the other side yesterday.
That's right.
He's confusing us.
Okay. John Bursch on behalf of National Heritage Academies. I intend to give 7 minutes of my time this morning to Assistant Solicitor General Catherine Dalzell and to reserve 5 minutes for rebuttal. I'll monitor my own time. Mr. Chief Justice, and may it please the Court, Mr. Hecht admits that when he commented in his third grade classroom that white tables are better than brown tables, he was saying that white people are better than brown people. And Hecht conceded at trial that while he deserved to be disciplined for his comment, other employees who had made racial remarks in the past did not. Now that is a concession that Hecht is not similarly situated to other employees, and therefore he cannot prove a prima facie case of employment discrimination. So what this dispute really comes down to is whether the Court of Appeals was correct that Corrine Weaver's testimony was direct evidence. If it was not, then his case has to be dismissed. I'm going to start with the similarly situated issue, which is the second question that you asked us to address, because I think it can be dealt with summarily. To be similarly situated, Hecht must show that he is nearly identical in all relevant respects to another employee who was treated differently. And here, Hecht conceded that he was not similarly situated when he said that he should be disciplined for his comments and other employees who had made remarks should not. That's dispositive. He is also not similarly situated for at least 3 additional reasons. Other racial remarks in the record did not take place in a classroom. None of the other employees' remarks were reported to the principal, and none of the other employees lied and interfered with a school investigation. Because Hecht is not similarly situated and was replaced by someone of the same race, he cannot satisfy his prima facie case. So really, again, this case comes down to whether this was direct evidence when Corrine Weaver gave her testimony. Now, in Hazel versus Ford Motor Company, this court adopted the federal standard for direct evidence of discrimination. It is evidence which, if believed, requires the conclusion that unlawful discrimination was at least a motivating factor in the employer's actions. That means there is no inference that has to be drawn between the evidence and the conclusion that there was racial discrimination. And here, Kane Smith's purported statement to Weaver is not direct evidence for 3 independent reasons. First, as Judge Wilder explained in his dissent, Weaver's mere belief about what she thought Kane Smith meant cannot be direct evidence, because such ambiguous testimony does not require the conclusion that Kane Smith fired Hecht because of his race. Otherwise, a plaintiff in every case could create a genuine issue of material fact simply by submitting his own affidavit that his employer's benign statement really had racial or age or other overtones to it, and that he was, in fact, intending to fire him because of race. And that can't be the case, that plaintiffs could so easily manufacture evidence that would allow a case to go to the jury. So that's reason number 1. Second, ambiguous comments are also not evidence. So even if you take away the fact that all this was a statement about what Weaver thought or believed Kane Smith said, and you simply assume that her testimony was that Kane Smith said it happens among African Americans and it's not the other way around, that is an ambiguous statement, and it's got at least 3 interpretations. It could have been her observation as to why African Americans were not offended by those previous remarks. It could have been an observation as to why the employees didn't report those other instances. Or it could mean that Kane Smith has a different standard for race-based remarks depending on the race of the speaker and the person who heard it. So when you've got multiple interpretations, some of which are benign, that cannot be direct evidence of discrimination. Again, the jury has to be able to conclude from that statement and nothing more, no inference, that the decision here to terminate was made because of Mr. Hecht's race. Now, even if you assume that that is not an ambiguous statement, what it is it's evidence that Kane Smith believes that race matters when someone is making one of these comments. It still doesn't prove that she terminated Hecht because of his race. There's no connection or direct linkage there. You still need to have an inference. And to demonstrate that, all you need to do is compare her comment here, the testimony here, with other cases where there was indisputably direct evidence. We have the Johnson case, cited at page 9 of the Manufacturers Association amicus brief. We already have 2 black VPs. I can't bring in a black provost. No inference required to determine that that is discrimination.
Can I go back to your statement about ambiguous, or your argument about ambiguous statements?
Yes.
How do you square that with DeBro, where this court recognized that the statement at issue in that case was open to different interpretations, but where at least one of them could be viewed as direct evidence that would be sufficient? How do you square your argument with that case?
Justice Viviano, I think you can distinguish DeBrow on its facts. And if you disagree with me on that, then I think that DeBrow needs to be overruled, and this court needs to maintain the standard that it gave in Hazel and since then about what direct evidence really means. I think it's distinguishable because in DeBrow, the decision maker's comment that the employee was getting too old for this nonsense was made during the conversation in which DeBrow was being fired. So at least it's plausible there that you could say there was a direct linkage between the statement about his old age and the termination. Here, in contrast, this took place in the context of a conversation where Weaver was telling Kane Smith for the very first time about some of these past remarks that had to do with race. It was very early in the decision-making process, and there's nothing.
It was 2 days before he was fired, wasn't it?
It was, but there's no indication in that conversation, as there was in DeBrow, that she thought that statement was in any way determinative of why she would then fire Hecht.
This is a discussion about what discipline might be meted out.
No, this was a discussion about the fact that there had been other racial remarks made in the past at the school of which the principal was not aware. So
why were they having the conversation? The incident had occurred.
Correct.
And they were trying to figure out what to do about the complaint about
Correct.
the racial remarks or alleged racial remarks, right?
Yes.
Okay. And Kane Smith is?
The principal.
Okay.
She is the decision maker.
The decision maker.
And it's undisputed that Kane Smith did not have any knowledge, prior knowledge, of these racial remarks that had made in the past.
But
so Weaver's bringing these to her for the first time.
Weaver's bringing those to attention.
Correct. And then she makes, allegedly, she denies that she made the remark at all. But, Weaver thinks that she meant it happens among African Americans and it's not the other way around. That wasn't a statement that went directly to whether he should be fired or not. It was her observation about why other racial-based remarks were not being reported to her. And the termination decision doesn't come until 2 days later after she learns that Mr. Hecht interfered with the investigation and lied to the administration several times about what happened.
Let's kind of figure out first whether we think this is direct evidence.
Yes.
What the Court of Appeals reported in its opinion was, it appears to be Weaver's interpretation of what Kane Smith said in their conversation.
Yes.
However, if you read the transcript following, the plaintiff's counsel asked under oath, I asked you this, did you tell Ms. Kane Smith that a lot of people make racial jokes? I did not say a lot. I said it happened, and that's what's in my deposition. More, and then finally, Okay, this is November 3rd, a few days before plaintiff was fired. Yes. Now, isn't it a fact that when you said Kane Smith responded by saying, quote, "It happens among African Americans and it's not the other way around," right? Yes. Now,
Yes.
this is not it is not Weaver's interpretation of what Smith said. He purports to be quoting what Kane Smith said.
Purports to be is the key part of that
Well,
question.
I understand, but
The reason the Court of Appeals,
you get in the context of our rules of evidence, if she said that, it's attributable against the defendant, correct?
don't disagree with that an
Okay.
iota.
So that's what we have before us. She says in this context, the racial jokes happens among African Americans, and it's not the other way around. Now that, in your view, is or is not evidence of racial thinking and discrimination?
Assuming for a second that that's the right testimony, and we explain in our reply brief why the Court of Appeals focuses on the "I believe she said" testimony, but I'll leave that aside and I'll go with the quote you gave me. That's still not direct evidence for two reasons. One, it's subject to multiple interpretations, some of which are benign, and that's not direct evidence. And two, even if you conclude that it's direct evidence that Kane Weaver thought that race-based remarks should be interpreted or perceived by the administration differently depending on the race of the speaker and the listener, it's still not direct evidence that she fired Hecht because of his race. And that's the critical thing that's missing here. There's not a direct link. There needs to be an inference. It's not.
So if somebody uses impermissible animus, illegal animus, that is outside the actual termination meeting, it's no longer direct animus, direct evidence.
Well, this court and the federal courts have long held that when you have so-called stray remarks, right, it's a racial remark, that is not direct evidence. That's not enough to get to a jury unless it's part of the termination decision itself, and sometimes not even then. This is less than a stray remark because she's not saying anything about Hecht's race. She's making an observation about what she thinks Weaver meant when she tells her, well, none of these other incidents have been reported to you. That's the missing link. And again, I want to just quickly tick off what the direct evidence cases.
Well, counsel, before you do that, can I just ask you, what exactly is this court's mission at this moment? Is it to continue to assess the evidence in light of whether it was direct or indirect, or is it instead to kind of move back from the trees of those distinctions and look at the larger forest and ask ourselves whether or not unlawful discrimination of any kind was at least a motivating factor in the discharge in this case? It seems to me the federal circuits that have looked at this have had some disagreements as to what the principal focus should be at this stage of the process.
Right, and actually you are still focused not on the trees, or the forest I mean, but on the trees. And Judge Wilder, I'll refer to his dissent because it's very good on this point. He explains that each stage of the litigation proceedings involves a challenge to the legal sufficiency of the evidence. So at the summary disposition stage, the directed verdict stage, the JNOV stage, which is where we are now, each time you must still determine whether the evidence was sufficient even to go to the jury. And as I've already discussed, he cannot prove a prima facie case. He just can't. There's no argument here that he was similarly situated in all relevant respects to other employees.
How would you characterize the current federal court's perspective on that matter?
On the similarly situated or the direct evidence?
On the direct evidence.
On the direct evidence, I think it's the same standard today that you adopted in Hazel, which is that direct evidence is only that evidence which requires a jury to draw the conclusion that there was racial discrimination that took place.
No, I don't mean on the definition of direct evidence, but I mean on the relevance of focusing on direct and indirect evidence and the distinctions and similarities between them at this stage of the judicial process.
It's been submitted to a jury.
Right. I think that the federal circuits are divided on that. But I believe that Judge Wilder explains that the majority position is the one that I just described, that at each stage, including the JNOV stage, you still need to determine whether an issue was properly submitted based on adequate evidence that a jury could reasonably conclude there was discrimination. And I think that this court should continue to follow that majority standard. In fact, I don't think you've departed from that in the past.
Does the plaintiff have to show discriminatory animus?
Oh, sure, absolutely. I mean, that's part of his case. And that's not just his prima facie case. At the end of the day, he cannot prevail unless he can demonstrate that the decision was made because of race. I mean, the statute is crystal clear on that, because of race. And this remark here does not allow him to establish that. That's why it could not have gone to the jury. It's not like we already have 2 black VPs, I can't bring in a black provost. It's not like the prospective employee was the wrong color. It's not like get rid of the older guys and replace them with younger ones. It's not like the DiCarlo case where there were too many dirty wops at the workplace in the context of a termination. It's not like Wexler.
Isn't there a distinction between discriminatory animus, a statement that shows either favoritism for a non-protected class or disfavoritism toward a protected class, and the standard that we stated in Hazel, whether consideration of a protected characteristic was a motivating factor, namely whether it made a difference in the contested employment decision?
Yes, Justice Viviano, you stated it better than I could. That's the difference between our second and third reasons why this wasn't direct evidence. The second reason is that it's ambiguous, and if there are benign interpretations,
but to
it's
agree
not
with
direct.
you on the ambiguous, you want us to overrule a case, right?
Well, like I said, I think you can distinguish that, but if you can't, then I think you should overrule it to make your case precedent consistent with Hazel. But the third reason is the one that you just drew. Even if you conclude that that was direct evidence that Kane Smith thought race made a difference in these conversations, that is not direct evidence that she fired Hecht because of his race. So that is a crucial line that you draw in determining what is and what is not direct evidence. Only the latter, direct evidence that he was fired because of his race, is sufficient to state a claim under the Elliott-Larsen Civil Rights Act.
Well, again, I think Justice Markman asks an interesting question. At the summary disposition point, where we're trying to analyze whether there's sufficient evidence to go forward, direct evidence propels you much further in that direction of
Yes.
it being jury submissible than a circumstantial case. In any event, if there is sufficient evidence of illegal animus, the case gets submitted to a jury, right?
Right, and you do that in 2 ways. You either have direct evidence or you satisfy your prima facie case under McDonnell Douglas.
Okay,
if you agree with me this is not direct evidence,
All right.
I think you have to agree with me that he can't establish his prima facie case.
Now, why is that?
Because one of the elements is to prove that he was replaced by someone of a different race. He was not. He was replaced by someone white. Or to prove that he was similarly situated in all relevant respects with another employee who was treated differently than he was.
Or illegal animus infected the decision.
Only if you've got direct evidence of that. The McDonnell Douglas prima facie case doesn't have animus as a factor. That's why you need direct
Michigan
evidence.
has recognized that as an independent basis, has it not?
Michigan has recognized that there is some flexibility in the prima facie case. So if you had a situation, for example, where an employment situation was replete with the decision maker making all kinds of racially charged statements, that your boss was David Duke, this court has recognized that that might be enough to dispense with McDonnell Douglas and allow that case to go to the jury. This is so far removed from that kind of situation, they're not even comparable. All she was doing was making an observation about the new evidence that had come to her about past remarks. And with that, I will reserve the balance of my time for Ms. Dalzell and for rebuttal. Thank you.
Is this the issue about the disclosure form?
Yes.
Catherine Dalzell here on behalf of the Attorney General. Thank you for allowing me to appear as amicus. And as Mr. Bursch indicated, I will be focusing on the scope of immunity for disclosing misconduct. I think there's a simple way to look at this issue, and I think...
Could you speak up?
Yes. Is that better? Thank you.
Anything is better.
Thank you. I think there's a simple way to look at this issue, and I think this case is a great example of why it's the right way to look at this issue. And that is to say that if there is true, real misconduct, the legislature wants that to be disclosed. The legislature did include a safety valve in the immunity statute for situations where it might be unfair to the employee, and that's the good faith requirement. That's the only safety valve the statute included, and it did not make a separate safety valve for the cause of action, what cause of action it is, and whether the disclosure formed the basis of the cause of action. The good faith requirement is the only one necessary, and that's because the purpose of the statute is to protect students and companies from unprofessional employees. And this case is a great illustration, I think, of how the statute works, and that's because it's not disputed that Mr. Hecht engaged in unprofessional conduct, and that's regardless of the reason for his termination. Mr. Hecht told an admittedly racial joke here. He told it within earshot of third graders. He involved a student in the joke. And, you know, Mr. Hecht says, well, the students couldn't hear, and the student I involved didn't hear. But frankly, it doesn't matter. The point is that these students could have heard, and they're third graders. And I actually don't see how it makes it better that the student he involved didn't hear, because he's asking a kid to affirm a statement about racial superiority, and the kid didn't even hear it. And he was using, you know, students as a pawn in his jokes with other adults. I think even on his interpretation that the students couldn't hear him, this is unprofessional behavior. And in fact, Mr. Hecht doesn't dispute that it was unprofessional behavior. He admits that the joke was tasteless, he admits that it was insensitive, and he admits that it was sanctionable. In all of his briefing, he never argues that his joke was either appropriate or not deserving of discipline. Instead, he just argues that other jokes should have been punished too, like his was. He's never tried to take advantage of the safety valve that the legislature specifically included in this immunity statute. He's never argued that the disclosure was not made in good faith. Again, the statute...
The argument is advanced that this immunity provision for disclosure is inapplicable because he wasn't using it to establish civil liability, only damages. Do you have an answer to that?
I do, and I think if you look at the plain text, and by that I mean a dictionary definition, either a regular Webster's dictionary or Black's Law Dictionary, liability is interpreted broadly. And I think what I would draw this court's attention to, in our brief we quoted the 8th edition of the Black's Law Dictionary because that's what we have in the office, but I've since pulled up the 6th edition, which was the edition of Black's Law Dictionary in force at the time that this statute was passed. So I think that that would be probably the best indication of what the legislature would have had in mind when it used these words, liability and civil liability, although the definitions are pretty similar. But the Black's Law Dictionary defines civil liability as a sum of money assessed either as general, special, or liquidated damages. It defines liability as the word liability is a broad legal term. It has been referred to as of the most comprehensive significance, including almost every character of hazard or responsibility, absolute, contingent, or likely. It goes on to define liability as, among other things, any kind of debt, that which one is under an obligation to pay, present, current, future, fixed, or contingent debts. So I think that's a very broad reading of liability. It's not limited to simply the merits of a cause of action. It includes suffering damages, and I think that's corroborated by this court's decision in Hanai, which is a recent decision. In that case, this court defined the phrase to be liable for something as to be legally responsible for damages flowing from that thing. So here, immunity from civil liability for the disclosure, which is what the statute states, would mean that the school is immune from legal responsibility for damages flowing from the disclosure. And I would emphasize here that the damages that Hecht is claiming, the school is being held responsible for $500,000 flowing from his unprofessional conduct. And that's because his unprofessional conduct is the basis of the disclosure. He's never argued that the disclosure is false. He's never argued that the school is reckless with regard to the disclosure. And that is what's causing him damages. The only fair measure of damages here is to hold him responsible, or to hold him to the standard of a teaching position that he could have gotten but for his own misconduct. And I think an example of that is helpful. Even if he's correct that his termination was on the basis of race, he would be entitled to lost wages between jobs, and say the average teacher salary was $55,000 that he could have gotten without his misconduct, and say his salary at NHA, and if I'm remembering correctly, I think it was $60,000. So in that case, based on the racial discrimination, again, assuming that happened, he would be entitled to $5,000 per year based on that. That's fair. What he can't get is what he got here, which is, I think it was $485,000, because he couldn't get a comparable salary because of the disclosure. And again, the disclosure was the result of his
Are you asking us to make a remediator here?
No.
It sounds like a remediator argument, not that the whole verdict predicated on these disclosures was invalid.
No. And in fact, I think the Attorney General...
What are you talking about fairness, then?
I'm simply saying I believe that the statute that the legislature made sense here.
If I understood your argument in the brief, if the disclosure form should not have been admitted for the jury's consideration, that portion of the verdict is invalid.
Correct. Our position is the school cannot be held liable because of the immunity under the statute. The school cannot be held liable for its disclosure because it defeats the purpose of the statute. I think the text is clear that there's no cause of action limitation. Good faith is the only limitation that the school included. Yes, and I'd like to save this for Mr. Bursch's rebuttal. Thank you.
May it please the Court, Glenn Lenhoff for Plaintiff Appellee Craig Hecht. Your Honors, I submit that the colloquy, the question that Chief Justice Young asked regarding the direct evidence issue should be dispositive today. The first question in your order granting leave was whether the Court of Appeals erred when it found sufficient direct evidence of racial discrimination on the basis of a witness's interpretation or understanding of what the defendant's representative said to her. But as the Chief Justice question just showed, this is not a case in which the witness, here Corrine Weaver, merely interpreted what decision-maker Kane Smith said. And I was going to read the passage from the transcript that Chief Justice Young just brought out. In fact, the witness, Corrine Weaver, testified as to what Ms. Kane Smith literally said to her. There's no interpretation at all. And consequently, this first question posed in your September 16th, 2015 order granting leave does not reflect what happened here. This is a case of pure direct evidence, no interpretation at all by witness Weaver. By witness Weaver, rather. Because of that, I would request that the Supreme Court rule that there was direct evidence. This is not a case of the witness interpreting what the decision maker said. So this is not the case to decide the issue of whether where a witness merely interprets what the decision maker said. Can that constitute direct evidence? That's not what happened here. We have testimony from the second in command, Weaver, as to what the decision maker literally said. And I submit that should be dispositive, and I don't believe that it's necessary even to get to the second question, the circumstantial evidence issue. That's my 2-minute synopsis
Actually, you
of
get
how I
5.
think it should go. I
You
really
get 5, are you waiving the remainder?
Right. Oh, no, I want to go on to the
Okay.
other issues.
Okay.
On the issue of direct evidence, you see, really, in the Court of Appeals opinion, the Court of Appeals really kind of misinterpreted the transcript too, the trial too, in the sense that the Court of Appeals pointed out, well, the Court of Appeals remarked this was Weaver's interpretation of what Kane-Smith said, and perhaps that's what led Judge Wilder in his dissent to make that point. Judge Wilder in his dissent pointed out there's nothing in the record indicating what the decision-maker Kane-Smith really said. In fact, as I just indicated, and as your question clearly indicated, the portion of the transcript you pointed to clearly establishes the record indeed does reflect what Kane-Smith said. But going to the law of direct evidence in general, what's the law of direct evidence in this state? There's always a little bit of interpretation as to anything, but the law of direct evidence is the DeBrow case, and the DeBrow case, I think, gives us something that we don't always get in law or life, clarity. And as we know, in DeBrow, the Michigan Supreme Court, this honorable court, adopted Chief Justice Young's opinion when you were on the Michigan Court of Appeals, when you were Judge Young. And this is the standard that you enunciated in your dissent in DeBrow. This is what it says, and I submit, this is clear. The law of direct evidence, as stated in your dissent in DeBrow, this is what it says. If the statement suggests that plaintiff's age was a factor in the mind of his employer, then it's direct evidence. That is clarity. And that's the law, because in DeBrow, this court, the Supreme Court, adopted your Chief Justice, then Judge Young's dissent.
Oh, I'm glad you're pleased with my opinion. But let me probe a bit. In DeBrow, the comment, which, as I recall, is "You're too old for this" expletive.
Right.
That was the termination conversation. You didn't have to have a lot of inferences about the state of mind of the decision maker in that context. Here, I want to at least question whether there isn't this situation isn't at least a standard deviation away from the DeBrow situation, in that this wasn't a communication directed necessarily at the plaintiff. It was a conversation. It wasn't a termination conversation. It may reflect some racial animus, or it may not. Why is there a direct inference of two things? One, that it was intended to reflect a legal animus, and second, and I think more important, directed specifically at the plaintiff in terms of the termination that occurred subsequently.
Okay. Well, first of all, I don't think the statement had to reflect animus. I think, as Justice Viviano brought up, it just has to reflect that race was a factor, that race was considered. In other words, we don't...
Well, I mean, if I mention race in a non-animus way, that doesn't make it actionable. It's only illegal animus that is ever actionable. The fact that race is mentioned as a descriptor, and everybody understands it's not designed, not reflective of a hostile and illegal animus. I mean, so you have to be very careful in this arena, because the statute doesn't ban people from using
Right.
gender or race as a descriptor.
That's true.
All right?
That's
so now,
true. Okay, well, I think another point you brought out in your questions, it was like a day before the plaintiff was fired, and the statement was made in the context of deciding what to do, of what discipline to mete out. So it's so close in time.
yeah, this might satisfy race, what might have been a factor, but I'm trying to figure out why this is that kind of lightning kind of thing, the direct evidence. Rarely do you have the decision maker saying, I'm firing you because you're white, you're old, you're black, whatever. That's pretty startling. This is, like I say, this strikes me as being at least a standard deviation away from it. You might make the inference that the decision maker had improper racial motivations in the way she treated the plaintiff, but I think that's what you have to have, is you have to make an inference from this comment, don't you?
Right. Well, you do. But see, the theory of racial discrimination in this case, it's one of the most well-settled areas of employment law. It's a disparate treatment and discipline case. It's a disparate treatment and discipline case. And the theory in this case is that...
That's not direct evidence. That's not direct evidence. I mean, I concede that a jury could look at this and say, this is the decision maker and this is how she thinks of the world. It's okay for some people to make these kinds of racial jokes and not others. I understand that. But if we're talking about direct evidence, I'm still having trouble understanding why this is inexorably the kind of evidence that the federal courts have recognized, the kinds that were discussed. You know, we already have 2 blacks, we can't hire a third. You don't have to think about that. You don't have to have an inference about what's motivating the person making that statement.
Well, the theory in this case
isn't disparate impact, isn't an intention to treat individuals in a disparate way really the core that's being focused on rather than animus? It's okay to have a racial animus. I don't mean it's a noble thing or it's an admirable quality, but there's nothing that's actionable about having an animus per se. It's only when that animus, or even an absence of animus, results in disparate treatment, isn't it?
Exactly. Exactly. I'm not saying that, we're not contending Linda Kane Smith hated white people. We're contending that in deciding what to do and deciding what discipline to mete out, she took into account the fact that Craig Hecht is white.
Right. That's what you can't do. You can't make a decision based on somebody's protected characteristics.
Exactly.
All right.
And
That's what animus
Okay.
means in the context of all these federal cases and ours.
True.
Doesn't mean you have to be hostily motivated toward all people of that protected. But if you use their protected characteristic, that's what the statute bans.
True. That's true. And
Counsel, the critical question here came on cross-examination, and it was a leading question. Does it mischaracterize the deposition testimony of the witness?
I don't think it does. And then could I make one other point with respect to that question?
Well, I mean,
was
you say you don't think it does. I mean, I guess I don't know what that means.
Okay.
So is there deposition testimony that this is based on? Because the deposition testimony that the Court of Appeals relied on didn't refer to a specific statement by the decision maker. Instead, it was this notion of the witness's interpretation of what she thought the decision maker may have meant.
I know, but the Court of Appeals that it's true, what you just said is true, but that remark by the Court of Appeals was not consistent with the record, with the testimony.
That's why the question to you from in the order asked you whether it was permissible to have direct evidence based on somebody's impression of a statement.
In defense of our order, it's the Court of Appeals' fault.
Yes. In short, yes. They didn't cite the provision of the testimony that was in the record that I started with. Okay, I'm sorry.
But that's okay. So, I mean, it is what it is. It appears to me that it's a mischaracterization of the testimony. So if you have a question and answer to show me that I'm wrong, fine.
do.
But
I do. And this would, well, actually, it's what Chief Justice Young read. Here we are at page 154 and 155, the trial transcript. And it's...
No, I'm aware of the trial testimony. My question was simply whether the question by counsel, the leading question, mischaracterized the deposition testimony. In other words, it wasn't based on what the testimony actually was. The trial counsel sort of cleverly asked a different question that provided better evidence for your client, and then the witness affirmed that statement. That's what it appears to me, and you're more familiar with the record than I am. That's why I'm asking you the question. Am I wrong to reach that conclusion? And then my follow-up question is, if I'm not wrong, and it did mischaracterize the deposition testimony, should that concern us?
Okay, well, I mean, in the trial, I tried the case. And I don't remember.
The deposition was, the answer was, I think her point was that it happens amongst African Americans, and it's not the other way around. And this one was reported. Someone was offended, and we had an obligation to follow up on it. The question was, now isn't it a fact that when you said that, Kane Smith responded by saying, quote, it happens among African Americans, and it's not the other way around?
And the answer is yes.
I agree. The witness affirmed the leading question. But if that's based on the deposition question that I just read, it would appear to be a mischaracterization of the question. But I don't want to argue with you.
Well, I don't.
Does it matter?
Yeah,
if that's what the jury heard and it wasn't corrected by opposing counsel saying, now wait a minute, you said yes, but that didn't occur. What we have is then what the jury was submitted to the jury, correct?
Yes. Yeah. I mean,
okay, which is fine. And so that my next question is, let's say that I agree with you and with what the Chief Justice just said, that the testimony, the trial testimony, and I agree that's the proper focus, doesn't show that the decision maker had racial animus. I think that's what you just said. You're not saying that she didn't like white people.
Does it show that? Yes. I mean,
all right. So then,
so
then the question is, and this is just trying to ask the same question maybe more simply, how does that testimony provide direct evidence, without inferences, direct evidence that race was the motivating factor in the decision to terminate that was made a few days later? And let me just be a little more specific, because as I read that question, or I'm sorry, the question and answer, that exchange, it's a description, the witness's description of a state of affairs. There's no indication that the decision maker approved of, thought it was okay, took steps to indicate this was the policy of the school, to make sure that there was more racial banter among one group than another. And so that's my concern. It appears to me to be an observation of a state of affairs that may have existed within the school. It does not appear to me to be a statement by the witness
Subscribing.
Yes, subscribing to it in some fashion. So how does it, just to ask the simple question, how does it provide direct evidence that the decision to terminate a few days later was based on an improper consideration of a racial characteristic?
Because under DeBrow, it suggests that race was a factor.
Yeah, but this has to be direct evidence, no inferences.
Suggest. That's the point. You require an inference.
I'll even go another step in your direction and say that even if it's ambiguous, give me your interpretation of the one version of the statement that it's direct evidence.
According to this testimony, Kane Smith, here were the players with respect to this. Weaver, the second in command, said to Kane Smith, there's a lot of racial jokes that go on. Then the decision maker said, it happens among African Americans, not the other way around. Okay, now, it's
and in fairness, as the testimony continues, the decision maker says, what's different about this one is someone was offended.
Right.
And if we look to the deposition, that testimony also was someone was offended and somebody complained. It was reported.
Right. It's true. It's true. And Justice Larson, I think you were asking, it's true, this doesn't say, well, Craig Hecht has to be fired because he's white. And
that's why it requires an inference. which destroys it as direct evidence. Whether we said it quite as well as we should have in Hazel, that's the essence of direct evidence. You don't have to think about it, because in DeBrow, at the very least, when your employer who's firing you says, I'm sorry, you're too old for this expletive, and then fires you, you don't really have to have a lot of inferences about what might have been motivating, at least in part, that decision. I'm sorry?
Can I respond to what you said?
Sure.
Yeah. There's a little inference. Okay, in DeBrow, the decision maker said, you're too old for this expletive.
Yes.
And he didn't say, I'm firing you because you're too old. So there was a little inference.
I understand. But I think, as I said, this case is at least a standard deviation away from DeBrow.
Not much of a deviation.
Well,
not much.
Standard deviation.
Pretty small.
Don't we have to infer in some fashion from this statement that the decision maker approved of this state of affairs? That perhaps she had an opportunity to do something about it and she didn't? You know, so you have to sort of think down the road that she had some way adopted this, that she approved of it. She thought it was a good thing.
I think it's true. But it's not much. But it's not much of an inference. I mean,
Why not?
Why?
Because of the fact that discharge is meted out to Mr. Hecht, and the decision maker, in deciding, in a discussion with her, in a discussion with the second in command person, Ms. Weaver, Ms. Weaver calls to her attention the fact that there's a lot of jokes that go on here of a racial nature, and then in response, Kane Smith says, but the jokes are between African Americans, not the other way around, and then the next day fires Mr. Hecht. I would think the statement in question does suggest
Well, the question
that
then
race
is,
was a factor.
again, if it's direct evidence, that's fine. If it's not, then it falls into the range of considerations. Is it a stray remark? Is it substantial enough so that it satisfies a part of your prima facie case under the McDonnell-Douglas paradigm? I mean, how we classify this is quite significant.
It is. It is. That's an interesting point you just made. Let's assume I think it's direct evidence, and pardon me, but let's assume arguendo that it's not direct evidence. Pretty powerful circumstantial evidence, and I'm okay. If you don't mind, I'll now go to the second issue.
But if you're on the road to disparate treatment evidence, I mean, I would agree with you. It's sort of the first step in maybe trying to show that the plaintiff was treated differently based on his race. But then don't you have some pretty significant problems with showing that he's similarly situated, as opposing counsel suggested?
Well, first of all, I think that's for the jury to determine. And I'm sitting there during
But you have to make a prima facie case before it can get to the jury. So that's what we're worrying about.
Okay, but isn't it a pretty significant as to the fourth element of the prima facie case? There's no dispute as to the first three elements, that he was white and that he was suffering an adverse action, that he was competent. The fourth element is, did the circumstances give rise to the inference that there was discrimination? And really, we don't have to show that by way of a similarly situated analysis, though in this case we are. But going to this fourth issue, the statement in question is very significant. One point that hasn't been brought out today is that the testimony was not from the plaintiff, as in DeBrow. In DeBrow, the plaintiff said, the decision maker told me I was too old for this, blank, for this expletive. In this case, the testimony was from the second in command of the defendant, which makes it particularly powerful evidence.
The credibility of the evidence is not really what we're struggling with. We're just struggling with whether it leads inexorably to the establishment of your fourth element.
Okay.
That he was either similarly situated and treated differently. That's where your case, if it does, founders.
Well,
don't you have to show that someone outside the plaintiff's protected class engaged in racial jokes or racial banter, then a complaint was made, and then the complaint was handled differently by the decision maker?
It's one way of that's one way of showing it. That's a similarly.
Can you show that in this case?
I think we can.
There
but-
were complaints against the
I'm
African
sorry.
Americans who engaged in racial banter that were not
Okay.
taken seriously?
I don't think we have to show that complaints were made.
How do you establish the fourth element here?
Okay, here's how I establish the fourth element. First of all, the statement that we've been discussing in the direct evidence context is supportive of the fourth element. And many times in opinions, opinions go off on this. Well, it may not be direct evidence, but it's very supportive of the fourth element, the circumstances showing.
Well, I think it gets you on that road, but and my question is, don't you have to show more? It starts to create a picture of the environment of the school,
Right.
but then don't you have to show for similar? I mean, what do you think you have to show to show that he was similarly situated but treated differently than someone else? Did you identify some other specific person at the school that was treated differently than your client, who's outside of his protected class?
We did. And I just want to move on to that issue, but as I pointed out, I don't think we have to satisfy the fourth element by showing a similarly situated individual.
How else would you do it? How else would you do it?
Okay.
In this case.
How else would we do it?
How did you do it in this case?
Okay.
Let's do it that way. That's more efficient.
Well, I think the similarly situated analysis, which I'm going to go into in a second, does it.
I'm asking how you did it.
How we did it was we pointed to an atmosphere of repeatedly tolerating these racial jokes. Now, it's true, as Justice Viviano just pointed out, I cannot point you to an instance in which there was a formal complaint made to the administration. As far as I know, there wasn't, but there is abundant evidence of racial jokes being tolerated. And if this
Racial
court...
jokes in the classroom by a teacher involving students?
The joke did not involve students.
Well,
Students were present.
Students were present
And
and
he
sort
admitted,
of brought into
your client
it.
admitted it.
My client did not admit students
In
heard
his
it.
his statement, one of several he made after the complaint, was there were students present when he said it. Now, that's different, isn't it?
He did testify there were students.
I want to make sure you at least get to the disclosure issue.
Okay. How much? I see
You have under 5 minutes.
All right.
Let me ask that question to you directly. In what way the statute provides immunity from all civil liability? If the legislature were attempting to extinguish the liability to a school system for making these disclosures, what broader language could it have selected than what's in this statute?
It couldn't have. We didn't sue the school district for making.
I know. I'm talking about the legislature. If the legislative goal was to say this is so important to us that schools disclose bad conduct to a potential employer of a teacher who's engaged in bad conduct, that's so important a public policy that we want to extinguish all liability for doing so. What broader language could the legislature have
It
selected?
couldn't have. It does extinguish liability for making statements.
All right.
For disclosing the
All right.
reason why.
Well, how then do you get to place before these jurors the very thing that I believe the legislature has immunized the school district from liability for? How can that be the source of damages if the goal of the legislation was to prevent them from being liable?
Well, the statute doesn't say anything about damages.
It says civil liability.
And
if you are liable for something, does that civilly liable for something? Does that include the damages? No.
No.
So when you're sued and you're found liable, you're not liable for the damages that flow from that liability.
Of course you are. But in this particular statute.
You think this only immunizes for defamation?
Yes, I was just going to.
Why does that? Why do you read it that way?
Because of the language. It says liability. It doesn't say anything about damages.
Are you familiar with some of the recent decisions from this court construing liability on, for example, the Government Tort Liability Act?
I try to be. Maybe I may not. I don't say I'm an expert on governmental liability.
How about
I try
Bradley? Bradley involved a case in which the Tort Liability Act precluded damages. I'm sorry, not Tort Liability Act. The statute precluded damages for any liability, any civil liability. I'm sorry, I'm looking at the wrong place. Sorry. Legal responsibility. Oh, okay. I'm sorry. I can't find the right quote. But both Bradley and Hannay construe liability.
Bradley legislature intended tort liability to encompass legal responsibility arising from a tort.
Right. Both undermine your notion that liability is unrelated to damages. Are you familiar with either?
I am not, Your Honor. I'm not. But in this case, the liability was based on a statute, the Elliott-Larsen Act, and to accept the defendant's argument would be to accept the proposition that you can't get damages in discrimination cases from school districts.
No, you can get damages. You just can't get them any that flow from the disclosure form. Well, that's a very different idea.
True. But what about the judge's instruction? The judge gave a pretty liberal. I mean, a pretty.
It doesn't matter if it is impermissible to put it before them at all, because it cannot be if the construction of any civil liability encompasses damages. If that's the proper construction, you can't put it in front of them because it destroys the immunity.
It is true. I readily acknowledge, as you just pointed out, this is not the same. The argument that's being asserted is not the same thing as saying you can't get damages.
No, but you can't. It's whether you can get damages for the disclosure form.
We did have a limiting instruction, and there's no.
The instructions didn't say you can't award damages flowing from the disclosure form, did it?
No.
If that were the case, you wouldn't have put it in front of them.
No.
Okay.
That evidence sure was
powerful,
explicatory as to what happened in this case. In fact,
I'm sure it was powerful.
Yeah, I mean,
but
in fact,
if the judge had ruled, you can't talk about the disclosure because there's immunity for the disclosure. Could you have then just otherwise proved
he couldn't get
that
a
your
job.
client couldn't get a job? Couldn't your client have introduced testimony about how he tried to get a job and couldn't get a job, and therefore recovered for those damages equally? Would it have been equally likely, or would it have been different?
Would have been equally likely. That's an interesting point, Your Honor. We probably could have shown that, but to show, I think what was interesting about the verdict, they did give him a lot of money for economic damages. They gave him nothing for emotional distress damages. They checked, yes, he suffered emotional distress. They gave him zero for emotional distress.
Juries are a wonderful thing, aren't they?
Yeah. They
Thank
are.
you.
Thank you, Your Honor.
Your Honors, this Court's review of a denial of a motion for summary disposition, a denial of a motion for directed verdict, or one for J&OV are all de novo. And in this context, you ask yourself, well, what are we actually deciding de novo? And Hazel tells us, this is at page 466 of the Michigan report, to determine whether there is a jury submissible issue on the ultimate fact question of unlawful discrimination. And at every one of those stages, as Judge Wilder explains, the prima facie case and the direct versus the indirect evidence standard are helpful in deciding that question. Here, Weaver's statement, standing alone, is insufficient to prove that ultimate fact that Hecht was terminated because of his race. It's not direct evidence. And really, I think the whole case here collapsed based on a two-word answer that my friend on the other side gave. Mr. Chief Justice, you said you have to have an inference here to go from the statement, even if you accept it the way he characterizes it, to the conclusion that he was terminated because of race. And his answer was, you do. You have to think about it. There's a suggestion there. There's an intermediate step.
But counsel, during the soliloquy, though, I think it was quite interesting because, when you're talking about the issue of direct evidence, in any situation, you're going to have inferences no matter what the direct evidence is. I mean, how do you have a situation where you don't have to draw an inference into a direct evidence statement?
What we have.
Otherwise, wouldn't the standard be, I am firing you explicitly and directly because of some racial reason? I mean, otherwise, wouldn't the standard be almost impossible to meet when you're determining what is direct evidence and what is not?
Justice Bernstein, I don't think so, because there are a plethora of examples in other direct evidence cases where there's no separation, no degree of separation between the animus and between the termination. We already have 2 black vice presidents. We don't need another one. That is direct evidence. It's like saying the light is green, and we don't have that here.
But aren't I still having to draw an inference? I'm still inferring from that. I still have to infer from what you just said. I mean, you're telling me there's no inference that is necessary in the statement that she made?
The way that this court describes the standard in Hazel is that the evidence, if believed, requires the conclusion that unlawful discrimination was at least a motivating factor in the employer's actions. And I think that the statement, we already have 2 black vice presidents, we don't need another one, requires the conclusion that unlawful discrimination was a factor. And so that's why he's then forced to jump to the prima facie case and try to argue on that 4th element. And you went back and forth. Well, there is nobody similarly situated here. He could not identify a comparator. He never did. And that is the issue that they got to trial on. That's the issue the Court of Appeals had analyzed. That's the issue that you asked us to discuss in this case. So what he says today is he can satisfy it by the fact that there was an atmosphere of repeated remarks in 10 to 20 years. And just briefly on that, first, there were only 10 to 20 remarks over a 10-year period. We're not talking about a pervasive culture. There's no record evidence of that. Second, the principal didn't know about that.
Was there a hostile work environment claim in this case?
There was no hostile work environment claim, nor could there be based on that record. The principal didn't know, and as you've already discussed, the students were present, and there was lying and interference with the investigation here. There was nothing similarly situated about him and anybody else at the National Heritage Academies.
But just to be clear, look, I understand your argument, and I've been listening very, very closely, and I guess the question is that you don't give any credence to the jury verdict, though. I mean, is that because ultimately there's still a fact finder in this situation, and so ultimately a jury, heard the testimony, heard the statement, heard what was said, and it's your contention that there's no, there should be nothing given to that jury.
That is my contention, yes, because ultimately, as a legal matter, the court is a gatekeeper as to what issues get to the jury. And if Weaver's statement standing alone is insufficient to prove directly the ultimate fact that Mr. Hecht was terminated because of his race, then the jury had no ability to consider this case. And that's the beginning and the end of the story. And respectfully, Justice Bernstein, if you adopted a different standard where even an indirect statement or a stray remark could be used to get to the jury, then there will never be a grant of summary disposition in another employment discrimination case in this state again.
Can I ask you one more time to clarify for me? Perhaps I'm slow in thinking about this, but what is the lodestone of direct discrimination? Is it animus? Is it disparate treatment? Or is it simply utilizing race or some other prohibited characteristic as a motivating factor in a particular decision?
If you look right at the statute, it's that there was an adverse employment action because of race or some other prohibited factor. So the racial animus, it can't be abstract animus. It has to be directly tied, because of is what the statute says, to the decision.
Why isn't that more compatible with a third of the options I just gave you, namely race as a motivating factor because of race? That's what because of suggests to me,
Well,
or as a result of.
I'm going to go even a little farther than your third thing, if you'll indulge me for 30 seconds so I can answer Justice Markman. The U.S. Supreme Court in Gross and Nacer, two cases that we discuss at footnote 3 on page 22 of our initial brief, have now clarified that at the federal level that simply a motivating factor isn't enough in a because of standard. Because of means this was the reason. So I think we win under the standard that you just articulated, but frankly, the standard under the plain language of the statutory text is even higher than that.
Let me ask one final question, if I can. Thank you for that answer. And this gets back to a matter I inquired about earlier. If we find this is not a case of direct discrimination, but indirect, and we have to apply the McDonnell-Douglas factor, I guess my review of the circuit court suggests that there seems to be near unanimity that the McDonnell-Douglas framework is irrelevant after trial. Have you set forth in your briefs some analysis of what the federal circuit courts have said about that?
I thought we did. I didn't see it when I just looked back at the brief now. We'd be happy to submit some supplemental authority on that.
In fact, I thought that in a 2000 case of Wilkinson versus Lee, this court, in fact, suggested the same and seemingly adopted the idea that the McDonnell-Douglas framework was irrelevant after trial. Are you familiar with the Wilkinson case?
I am familiar with that. I think
Am I
that
mischaracterizing it in your judgment?
I don't think you're mischaracterizing it, but I think Hazel does say that ultimately the determination is whether there's a jury submissible issue on the ultimate fact. And whether you apply the McDonnell-Douglas framework or not, there is not evidence in this record that creates a jury submissible issue on the ultimate fact question of whether Mr. Hecht was terminated because of race. So even if you dispense with McDonnell-Douglas, McDonnell-Douglas and direct versus indirect are helpful in understanding how to resolve that question.
Well,
but even in the absence of
once the jury
that,
gets the case,
I'm sorry?
if the analytic framework,
Yes.
the pretrial analytic framework of the McDonnell-Douglas paradigm becomes irrelevant after it's submitted to the court, to the jury, where are you? What do we do now?
You're
the
still
egg has been
reviewing.
scrambled. The jury gets to look at it. They said there's liability. What do we do with that?
Yeah,
now?
we disagree that that's the approach. We think you should use the framework. But I refer
I
you
know,
right
but
back.
if the framework goes
If the
out
framework
the
goes away,
yeah, then what?
you still have to, under Hazel, determine whether there is a jury submissible issue on the ultimate fact question of unlawful discrimination. And the
You
statement
mean
here,
whether there was one? Because
Whether
it's
there-
already been submitted to.
correct, right, whether there was a jury submissible fact of the ultimate fact question of whether he was terminated because of race. And this one ambiguous statement doesn't do
Now we should
it.
indulge every inference in favor of the jury verdict, right?
You would, but even then, I mean, Justice Viviano is the one who drew the appropriate line here. Even if you draw every inference in favor of Mr. Hecht, and you say, yes, what she was saying was infused with some racial meaning, it still had to do with the comments. It didn't have to do with his termination. And absent that linkage, you can't submit to the jury the ultimate question of fact. It's not there.
Thank you.
But actually, really quick, I just want to press you, counsel, and then we're going to wrap up, because I know this has been a really very fruitful conversation, actually.
Good.
And I guess I just want to press you on the statement that you made, because I want to have a better understanding of it. You basically stated that if we were to rule, in favor of the plaintiff in this matter, you would never have a summary disposition in favor of a defendant in this state again. That's a pretty bold statement. And I guess what I'd like to do is I want to press you on that just a little bit. And I want to just ask you, if I were to look at that in a converse fashion, isn't it possible that if you were to go the other way, that you would never really be able to have an actual discrimination claim filed in this state? Because in this situation, you have a jury verdict. In this situation, it was a sizable jury verdict. But in this situation, you also had, and we have this debate going as to whether it was direct testimony, but you have a statement that basically went to the heart of the case that was ultimately made. So do you feel that based off of your statement that, it would go in the other direction in such a dramatic fashion, that ultimately do you feel that if we rule in favor of you, that you would never be able to have a case put forth that would be able to meet the elements and the standard that you've set forth today?
Not at all, Justice Bernstein.
That's a surprise.
Because the McDonnell-Douglas factors aren't that difficult to satisfy. And typically, that's the way that plaintiffs get to juries. And to the extent they don't have that, we've got at least half a dozen examples in our brief, in the Manufacturers Association amicus brief, and in Mr. Hecht's brief, where there was direct evidence that was enough to get to the jury.
Thank you.
Thank you.
Oh, actually, I'm sorry. I'm just going to ask one more question. But isn't the, well, this is important, but isn't the statute and the law designed in these situations to deal with the exact issues that we've been dealing with today, which is that you are rarely going to have a situation when you're talking about direct evidence and when you're talking about the factor of this situation, that when you're talking about this, that you're really going to have a situation where someone is going to just simply come forth and say quite specifically, quite intensely, that doesn't require any inference, I am letting you go, or you are not fit for this position, and give a very highly specific reason. Isn't the reason that we have this case and why we haven't decided is because of the subtleties that go into these kind of cases, and it's those subtleties that go to the issue of direct versus indirect testimony.
Yeah, Justice Bernstein, that's a very good point, but the outcome actually is the exact opposite. The reason that we have the McDonnell-Douglas framework, which is not a difficult framework to satisfy, is precisely because it's difficult to have direct evidence. There is no other context outside of employment law where you would have such a low barrier of entry to get to the fact finder as you do with the McDonnell-Douglas four-factor test. And the reason is because it is hard to find direct evidence, and it should be hard to find direct evidence. But if you don't satisfy the McDonnell-Douglas framework, as they did not here, and I think that's crystal clear, then stray remarks are not enough.
Thank you.
Thank you.
Third time's the charm.